Okay, this is case number 23-17423 DN Kloosterman versus Kloosterman. Today's date is November 28th, 2023. This is a date and time set for our continued hearing on all child-related issues. Ms. Schmeltzer, you and your client are top left to me. If you just state your names for the record, please.
Lori Schmelter on behalf of the defendant, counter plaintiff Kevin Kloosterman, who is also appearing via Zoom and present in my office today.
Kevin Kloosterman.
Thank you. Ms. Lentz, same with your client, please.
Thank you, Your Honor. Elena Lentz on the behalf of the plaintiff, Jen Kloosterman, who is appearing next to me via Zoom today as well. Jen, do you want to go ahead and state your name?
Yep, Jennifer Kloosterman.
Thank you. And we just had a brief discussion off the record. We were scheduled to continue with Mr. Kloosterman, but we have a different witness. We're going to start with that person. I believe that there's no objection. Is that correct, Ms. Lentz?
Correct, Your Honor.
We're just taking this person out of order so that we can let her go back to whatever she's going to do today. So your next witness, please, Ms. Schmeltzer.
I would like to call Mindy Hill.
Thank you.
His phone is underneath your chair. You might be looking for that.
Ms. Hill?
Yes.
Good morning. You've been called as a witness in this matter by Ms. Schmeltzer and her client. She's going to have some questions for you. And then if she chooses to, Ms. Lentz may have some questions for you, okay?
Okay.
All right. I'd ask you to raise your right hand, please.
Mhm.
Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Ms. Schmeltzer.
Thank you. Ms. Hill, can you please state your name and spell it for the record?
Yep, it's Mindy Hill, MINDYHILL.
Thank you. And where are you presently employed?
I'm employed with DHHS. I'm a CPS investigator.
Would that be the Department of Health and Human Services of Michigan, Child Protective Services? Is that what those abbreviations stand for?
Yes.
And what's your job title there?
I am a CPS investigator.
How long have you been employed with DHHS?
Since 2019.
Have you been a CPS investigator that entire time, or have you changed positions?
I was a foster care specialist for part of that time.
When did you become a CPS investigator?
In February of 2022.
And prior to your employment in 2019, have you been employed in a similar capacity elsewhere?
Not doing this type of work, no.
And so what education, degrees, certificates, or training do you have that qualifies you for the position you hold with the Department of Health and Human Services and Child Protective Services as an investigator?
My background degree is in criminal justice. I have a bachelor's in criminal justice. And then through my employment, we do various trainings to become a state worker. You go through a 9-week training right off the get-go as far as training of how to do investigations, how to interview, kind of the whole process. And then year to year, you have to do so many hours of continued education as well.
What are your general job requirements?
As a CPS investigator, just in general, like what we do, or I guess, can you be more specific? That's like really broad, I guess, as far as like an investigation, like what we're supposed to be doing, or?
Well, I'm asking what your job requirements are as an investigator from a general perspective. We're just trying to get some understanding in that general sense.
Okay. Well, I can kind of explain, I guess, when I get an investigation and what I'm supposed to be doing with that. So when we get an investigation, I mean, we have allegations before us, and part of it is what we have to do is we have to go see the victim children who are involved. Everybody in an investigation has to be interviewed, including the children, parents, any adults involved in that. I mean, the overall sense is we're here to make sure children are safe and okay. We're here to provide services to families if they're not. I guess I don't know exactly where you want me to go with everything.
Sure. So, would it be fair to say that as part of your job duties, you investigate through various means and tools that you have available to you allegations of child abuse and neglect?
Yes.
And you said the word victim. Did you mean alleged victim? Since at the point of the initiation of an investigation, you don't know if somebody actually is a victim.
Correct. Whoever's listed as a victim on our complaint.
And do you know either or both Miss Jennifer Kloosterman and Mr. Kevin Kloosterman?
Yes,
And did you come to know them in the capacity of your employment?
I did.
Did you also come to know the minor children, Kelvin, Kelsey, and Callie Kloosterman?
Yes,
And again, was that through the capacity of your employment?
it was.
You don't have any other knowledge or interactions with this family outside of your professional relationship, correct?
Correct.
If you recall, when did you first come into contact with any member of this family?
The investigation came in over the summer. It was around the end of July.
And who was the first person in the family that you made contact with?
It was Jennifer, was my first contact with the family.
And why did you choose to contact Miss Kloosterman first?
I mean, every investigation's a little bit different. Typically, though, we would not contact the parent that's listed as the perpetrator first in our investigation. Jennifer was listed as the non-offending parent at alleged, and that's kind of where we would start our investigation with.
And so you said the end of July. Would it have been you received a complaint with allegations around July 27th of 2023? Is that correct?
Yes, I believe that was the intake date.
Do you know how the allegations came into CPS to investigate?
Are you asking like who the reporting person was, or?
Well, there's various methods that CPS receives allegations, right? There's central intake, there's forms that people fill out. Do you know how these allegations came to be on your desk to investigate?
Yep. So whether there's forms or calls or whatever, it all goes to centralized intake, and then they make a decision there if it's being assigned or not. And then from centralized intake, it then gets assigned to the local county.
And then it gets assigned to you or someone in your position, correct?
Yes.
So when you first see an allegation come across your desk and you're assigned to investigate it, what do you do?
We pick up the phone, we start making calls, we go out in the field, we make contact with individuals. We start the process of the investigation.
And did you follow that standard procedure in this matter?
Yes, I did.
These allegations came to CPS through a Dana McCarthy at Traverse City Women's Resource Center. Is that correct?
I'm going to object because the identity of the CPS reporter is protected by statute unless this court orders her to answer. But I think that the purpose of that statute overrides the answer.
Well, if that was the case, Your Honor, then I don't know why it specifically says that in one of the very first statements in the report that was produced by CPS to me without redaction. I'm looking at page 3, which I believe this report was also shared with Ms. Lentz, and it says this case was commenced with Dana McCarthy at Traverse WRC, and I'm simply asking Ms. Hill about the report she authored.
Yeah, I don't think it's necessary for us to know who submitted it. I mean, let's get to why we have this witness on this case.
Your Honor, if I may place on the record, the reason is that these allegations ultimately, our position is they stemmed from Ms. Kloosterman. And in fact, Ms. Kloosterman is the only person that has made any of these allegations. I think that's important, or I'm going to argue that that's important for this court to take into consideration.
Sure, I think you can ask this witness about what Ms. Kloosterman has said and everything like that and get that evidence on the record. I don't think it's necessary for us to identify someone who I do believe is protected by the statute from identifying.
Ms. Hill, in your investigation, did you find that the person who reported these allegations had any firsthand observations of Ms. Kloosterman or these 3 children with respect to the allegations?
I guess that's kind of in talking with the reporting source again. I don't want to, I guess, say something that would necessarily give the reporting source away unless I'm ordered to testify as to who the reporting source is.
That's not what you're being asked. You're just being asked if you know whether the person has firsthand knowledge, and I think it's an appropriate question. I don't believe I have to order you to do anything other than answer a question that you've been asked. Okay.
Okay.
Thank you.
No, to my knowledge, they don't have direct contact with the kids and the parents.
So is it fair to say through your investigation that the reporting source was reporting to you, to CPS, what Ms. Kloosterman told them?
That would be an accurate statement.
So going back here, July 27th, 2023, you received the allegations. That was a Thursday, correct?
I do not have a calendar in front of me, but I do believe it was July 27th is when the intake came in.
So if a calendar reflects that July 27th is a Thursday, you have no reason to disagree with that?
No.
When you received these allegations, did you come to know or learn that Mr. and Mrs. Kloosterman were going through a divorce?
Yes, I did.
Okay. And they were also going through a contested custody, for lack of a better word, battle at that time.
Yes, it appeared to be so.
And were you also made aware that there was a temporary order issued by this court for joint physical and legal custody between the parents?
Yes.
And that was something you knew as of Friday, July 28th, correct?
Yes. Yep.
That's when you spoke to Ms. Kloosterman. Is that July 28th, Friday?
Yes.
And did Ms. Kloosterman share with you that Mr. Kloosterman was due to receive parenting time, and there was a parenting time exchange pursuant to this court's order scheduled for Sunday, July 30th?
Yes.
So that was known as of Friday, July 28th, correct?
Correct.
Okay. What were the allegations that you were charged with investigating in this matter?
Do you want me to read the allegations specifically or
from your memory?
Okay. The concerns came in regards to improper supervision and sexual abuse allegations with his oldest daughter. There was concerns that Kevin was displaying grooming behaviors, paying the children to do various things, including paying them to take their swim tops off, to swim topless around their boat. And there was also concerns regarding previous domestic violence in the home as well, stating that the children have witnessed those interactions between their mom and dad.
And did you determine at any point in the investigation to make it a joint investigation with law enforcement?
Yes.
Why did you do that?
It's CPS policy. If anytime there's a physical injury case or a sexual abuse allegations being made, that we would send, it's called a law enforcement notification over. At that point in time, they would make a decision whether or not they're going to do a joint investigation with us, which in this case they did.
So not all CPS investigations of alleged abuse or neglect are joint investigations with law enforcement, just certain types. Is that a fair summary of your testimony?
Yes.
And procedurally speaking, even if CPS and law enforcement are jointly investigating, you each could come to a different conclusion. Is that correct?
Yes.
And is that simply the difference between the nature and capacity of each branch of the government you're working with, law enforcement versus CPS?
Correct. There's different statutes, I guess you could say, criminal versus CPS.
And so sometimes you guys come to the same conclusion, sometimes different. Is that fair?
Yes.
So what's the point of the joint investigation then, if you're ultimately making your own independent conclusion?
If any complaint comes in, could be criminal in nature. So typically something that's physical abuse or sexual abuse can be also criminal in nature, where a parent could be charged if the allegations are found to be true.
So I guess to question differently, why jointly investigate instead of independently each investigate?
The purpose of the joint investigations, for one, is to not be interviewing people multiple times, especially when it comes to children. In this specific case, the children were interviewed at the Children's Advocacy Center, but really it's just so that there's not multiple people getting multiple different interviews in that sense.
And at that point, also, would it be fair to say that if there's a joint investigation, CPS and law enforcement are sharing information and receiving the same information in their investigations?
Yes, typically that's how it would work.
Kind of turning back to Friday, July 28th, you spoke with and interviewed Ms. Kloosterman upon opening the investigation, correct?
I had like my initial contact, I guess you could say, with her.
And with speaking with Ms. Kloosterman at that, I guess that initial contact is what I'm talking about. Did she relay facts that she believed supported the allegations you were investigating?
Yes, we talked about the allegations, and basically that in her eyes, those things were truthful.
And you came to learn that the source of those allegations was Ms. Kloosterman, whether she made the report or not.
Correct.
Throughout your entire investigation, did anyone that you contact or interview other than Ms. Kloosterman or someone that was repeating what Ms. Kloosterman told them relay any facts of firsthand observations they made independently to support these allegations?
No, it was not found in this investigation that those were supported, I guess, or found to be truthful.
So the sole source of the allegations was Ms. Kloosterman, or somebody she told something to that had no other independent knowledge, right?
Correct.
Okay. At the conclusion of meeting with Ms. Kloosterman, did you determine that you needed to interview the children, or that they needed to be interviewed in general?
After my first contact with Ms. Kloosterman?
Correct.
Yes. And again, in any investigation, we can't just stop after one contact is made. We have to follow through and make sure everybody is contacted and interviewed.
Did you interview the children that day?
Not on Friday, no.
Why not?
So whenever there's, again, allegations of sexual abuse or something in that nature, typically what we would like to do is have a children interviewed at the Children Advocacy Center. That's the, I guess, plan A in most cases. That's the best outcome to do it there. It was also a joint investigation, so we cannot move forward with interviewing a child without law enforcement's lead as well.
In every incident of you investigating allegations of abuse or neglect, do you always schedule appointments for children to be interviewed at the Children's Advocacy Center, or is that just sometimes?
That is sometimes, but typically in a manner of this, we would do that almost every time. Yes.
So specifically, why in this particular case did you choose that option of interviews at the CAC, the Children's Advocacy Center?
Due to the concerns of the sexual abuse allegations and because it was a joint investigation with law enforcement and we were taking their lead as to what they wanted to do.
What's the difference between you interviewing right then and there at the home, the children, versus doing it at the Children's Advocacy Center?
CPS has no way to record a conversation. So if we don't have law enforcement with us, it's not recorded at the CAC, it is recorded.
And so it was important for you to determine that this interview needed to be recorded with these children in this case.
Again, it's because it's a joint investigation with law enforcement. We don't have that option to move forward without the lead of law enforcement, and that was the decision made for this case.
At the time that you were talking to Ms. Klusterman on Friday the 28th, knowing that the children were due to be exchanged with Mr. Klusterman on Sunday, what was discussed regarding that?
There was a safety plan put in place that until the children could be interviewed, they would stay with their mother.
When you did that safety plan, who made that determination? Who was the one who had the idea to put that on that piece of paper?
Myself and talking with my supervisor.
Okay. And did you inform Ms. Klusterman that CPS did not have the legal authority to advise her or tell her in any way that she could violate a court order?
I don't remember, I guess, our specific conversation. I do believe that has came up in conversation with her. I know I too reached out to friend of the court in regards to the safety plan to let them know that we were involved and that we did put that in place. And I believe I sent friend of the court a copy of that safety plan as well.
Well, I guess, do you believe you have the authority to tell parents to violate court orders?
We don't necessarily have the authority, but in cases like this, we do create safety plans, and sometimes a parent will file for a parenting time violation. Most of the cases, I would say they don't. They try to work it out later after the investigation's over. But we do this in many cases.
You spoke to me on Friday, July 28th, didn't you?
I believe so.
And your supervisor spoke to me as well, correct?
Yes, I believe so.
And there was discussion about the fact that CPS did not have legal authority to tell Ms. Klusterman to violate a court order, correct?
Yes.
Did you relay that to Ms. Klusterman at that time?
Honestly, I don't recall the specifics in the conversations. I know me and Miss Klusterman did have several text communication conversations on the phone. I don't know exactly on that day if we talked about it the day after.
If your report says CPS Hill let Jennifer know that CPS could not trump a FOC court order, but that she may still safety plan with her that she will keep the children until interviews were completed, does that jog your memory as to what happened or what conversation was had with Ms. Klusterman?
Yes.
Okay, so is it your recollection that you did in fact tell Ms. Kloosterman that you had no authority to tell her to violate this court's order?
Yes.
Okay. Nonetheless, part of the safety plan was that she would violate the court's order by keeping the children from the exchange on Sunday that was court ordered, correct?
Yes, that would be violating the court order.
And I was asking more that was part of the safety plan, right? And did you tell Ms. Kloosterman that she needed to talk to her lawyer about that before she did it?
I may have said that you can talk with your lawyer. Again, CPS safety plans are voluntary. We write them down. We hope parents follow them. That's, I guess, as far as a safety plan, I can just say that they're voluntary with parents.
Did you tell Ms. Kloosterman that the safety plan was voluntary?
I don't know specifically what I said as to that. So I can't, I guess I don't recall specifically what I said about that.
So if you told me when we talked on Friday, July 28th, that the safety plan was directed by Ms. Kloosterman, you communicated to her that she needed to talk to her lawyer and that it was voluntary, was your communication to me correct or incorrect on July 28th with respect to what you told Ms. Kloosterman?
As far as, what do you mean?
You told me all those things, that you relayed to Ms. Kloosterman she needed to talk to her lawyer, that you didn't have the authority to tell her to violate a court order, that that the safety plan was voluntary and that the safety plan was directed by Ms. Kloosterman. That's all the things that you told me. So when you told me those things on Friday, July 28th, was that a true statement of what you told Ms. Kloosterman that day?
Yes, I believe so. In the conversations that we had, yes.
When was the interview with the children scheduled to occur at the Children's Advocacy Center, the CAC?
It was scheduled the following week. I believe it was Tuesday of the following week.
Would that have been August 1st of 2023?
Correct.
And when these interviews were conducted, were they joint or separate? Meaning, were all the children together or separated?
They're all separated individually.
Was either parent in any of the interviews, or was it just the children by themselves?
Only the children with the interviewer in the room.
Okay. Who conducted the interviews? Do you know?
It was a staff member at the Children's Advocacy Center. I don't recall her name off the top of my head. There's a couple different ones.
Were you present to observe these interviews firsthand?
Yes.
And how did
we're I guess not present as far as from the child's perspective. It's behind a video screen. We're in a separate room.
Okay. But you were watching these interviews live, is that correct?
Correct.
But as far as the children knew, it was just them and the person, the interviewer, that we don't know the name of.
Yes.
Are you trained in something called forensic interviewing of children?
Yes, I am.
Can you explain to the court what forensic interviewing means?
Forensic interview is basically a protocol that's followed. You would start out with, typically, if you're following the protocol exactly step by step, you would start out with introductions. You would talk about a neutral topic to build a rapport with a child. You would do kind of a practice interview essentially with them, for them to kind of speak regarding details. You would go over the forensic interview rules to make sure that they have an understanding. Those rules are to always tell the truth. You go over the difference between a truth and a lie. You go over to correct the person speaking if they're wrong. to never guess an answer and to ask if they don't understand something, and just making sure that they understand each of those by giving examples if needed. Then forensic interview it's child-led, so we're not asking leading questions, we're asking open-ended questions, clarifying questions. And that's kind of the process.
And is it fair to say then that the point of going through this process with children is to determine if a child's statements are a truth or a lie?
Yes.
What training have you had on how to conduct forensic interviews with children?
We have that initially in our 9-week training. Over the course of 3 days, we go through it. Then various times, year after year, we have different one-day trainings, just various things that come up that we can do a refresher.
And what training, if you know, was the person who conducted the interviews? What training did they have on how to conduct forensic interviews with children?
They would have the same training. So anyone, whether it's law enforcement, CPS, you have to go through a 3-day forensic interview training for initial, I guess, certification.
And since you're trained and certified in forensic interviewing of children, if you're observing somebody else forensically interviewing a child, is it fair to say you'd be able to detect whether they're doing it right or wrong?
Yes.
In your observations of the interviews with these children in this matter, were the proper forensic interview protocols followed?
Yes.
And were you and the interviewer and law enforcement, were you able to determine or make a judgment that these children were understanding the difference between telling a truth and a lie?
Yes, they all were.
And were the children in this matter, were they cooperative and open in the interviews and answering questions and providing information?
Yes.
Do you know the ages of these children?
I'm probably not going to get them right. I believe 15, 13, and 9, maybe.
If Kelsey was 10 at the
Oh,
time of
okay.
the investigation, does that sound right?
Yes.
10, 13, 15. Do ages matter when you're trying to determine if a child is telling a truth or a lie, or their statements are reliable?
Yes, I mean, they have to be able to answer, I guess, the forensic interview rules correctly. We usually give examples, and if they get them wrong and don't understand the rules, then it's not really I guess you can say, forensic interview.
So, for example, if you were interviewing a 2-year-old child, that would be different than interviewing a 10-year-old child, just simply where they are developmentally. Is that fair to say?
Yes.
With a 10, 13, 15-year-old, in general, would you expect that child to be more developmentally advanced to be able to disclose and share information truthfully?
Yes.
And in this particular case, were you aware of any sort of learning or cognitive impairments that any of these children have that may have affected any of their statements in these interviews?
No, they all seemed like very bright children.
With respect to Callie, when she was interviewed, did she corroborate any of the allegations, deny them, not say anything? What happened there?
So we don't like necessarily read the allegations to the child. It's more open-ended questions, getting information out of them. And through the disclosures, there was nothing, I guess, brought up in regards to the allegations, no matter what the interviewer tried to, I guess, press a little bit. Like I said, we're not directly asking the allegations to the child because it has to be open-ended. We can't ask leading questions. but there was never any disclosures of any concerns.
I mean, do you talk about, body safety or generalize what the topic is of the allegations?
Correct, yes.
And do you ask about safety concerns?
Yes, yep. And there, through any of the interviews, there was no disclosures of any concerns or feeling uncomfortable with dad or around dad or going over to his house. There
And we'll
wasn't
get to that in a moment. I want to talk about Callie right now.
Okay.
So she made no concerns about safety in either parent's home. Is that correct?
correct.
Did she talk at all about the allegation or make any statements regarding the allegation that Miss Kloosterman made that Mr. Kloosterman was kissing her anywhere other than the forehead, such as I think one of the allegations was up and down the leg? Did she say anything about that?
I'm gonna object. I believe the witness testified that there was no concerns disclosed by the child. I think we're trying to circumvent hearsay here and get into exactly what the child said. I think the testimony that there was no disclosure is sufficient.
Well, for purposes of this hearing, I agree, but I mean, she can say whether or not, she said that she didn't go over the exact allegations with the child, so we already know that the child didn't relay any information. Are you just trying to follow up on more specific allegations, Ms. Schmelzer, that there's no evidence, there's no testimony on?
Well, yes, and I would argue also this is an exception to the hearsay rule because it is the investigation of an allegation of abuse or neglect and the children's statements in response to that. Here's where we're going though, is Ms. Kloosterman made a lot of very specific allegations, and we're looking into an investigation about them because Ms. Kloosterman also brought those up when we were here a month ago.
And I think we're all aware they were
closed.
unsubstantiated. And there was no disclosure.
She testified to them in her direct testimony, and I'm presenting contrary evidence. That's isn't that what what court is?
It is, but I guess the issue is, that the children didn't say anything related to the allegations. So what more, isn't that the answer you want anyway? How much more do you want than that?
As much as I think that what I know is not what the court knows. I mean, that's what this exercise is informing the court of all the information necessary to make a decision. So I know a lot of stuff. I'm sure Ms. Lentz knows a lot of stuff, but we're here trying to bring witnesses to inform the court of the stuff we know that's relevant to these proceedings.
Right, but by that own admission, that this witness isn't going to disclose anything like that because she's already testified she doesn't. So you're asking questions that you already know the answer to, which is there's nothing there. Why would you ask
that's
that
trial practice 101 is never ask a witness a question you don't know the answer to. But I don't know what you know, Your Honor. That's the issue. Is I'm trying to inform the court. That's the exercise of the judicial process.
I don't believe that we're going to be able to get into the children's statement in this. I don't think that your question in and of itself, look, I'll be honest, I don't think that the question to which there's an objection pending right now was inappropriate, but I think that it's just superfluous. I think you're just asking basically the same question over and over again in a different way. That this wasn't substantiated. This witness already testified. So I know, if you keep saying it that way, the court does know that there wasn't anything said during this interview. And now you're just asking the same question in a different way. Did they say this? Did they say this? And you already know, and I already know they didn't. So
if it helps, we can stipulate that the investigation was unsubstantiated and the children didn't disclose anything. There.
And I don't want to. I think that it's okay if you're asking questions about whether you believe Ms. Kloosterman was telling the truth or whatever. I think that those are appropriate, and I've already allowed those. I don't believe that's what you're doing right now. You are asking about what the children said.
I'm asking about. I didn't ask the specific statements of the children. I understand that was the objection, but I'm asking about the specific allegations Ms. Kloosterman made and the investigation And I mean, this all goes to impeachment issues of Miss Kloosterman. I mean, Miss Kloosterman opened the door. She did. She testified that she believed these things were occurring in October when we were here, fully knowing this investigation had been concluded and she had been informed of the outcome of it. I wouldn't have this witness here had Miss Kloosterman not opened that door. And I would like to make the record to fully explore those issues, because it not only goes to impeachment issues, it also goes to the issue of the weight that this court may or may not put on Ms. Kloosterman being the only one making allegations, which parent is willing to facilitate a close and continuing relationship with the children. And, you know, my job is to present all of the information, because I don't know what the court knows or doesn't know. I don't know what the court, furthermore, I'm making a record for my client of all of the information that is available to this court. That's all I'm doing, is asking those questions so that the court has all of the information. I don't fully understand I guess what I'm hearing is the court saying, I have enough information, stop giving me more. And I believe it's my duty as a lawyer to present all of the information. Whether the court weighs it or considers it is what happens after all of the information is presented.
That's not what I said at all. That's a total mischaracterization. The issue is, you can ask, the way you framed the question, you asked what the child said. So you aren't asking about Ms. Kloosterman. So my point is, here's the issue. You're now getting into, I believe you're saying there's a specific allegation of kissing in an inappropriate way. I'll summarize it that way. This witness already testified that the children didn't substantiate any of the allegations. So if you're saying that's an allegation, you're just rephrasing that question. That's all I'm saying. I'm not preventing you from asking the same question a different way. It's just, you have to determine whether it's necessary to go through all these things when you know that the court does know, for a fact, the court knows that none of these allegations were substantiated. Whether you state them specifically or broadly, you are aware of that based on the testimony that was presented not 2 minutes ago. So that's up to you. But I'm not really going to get into whether the children are specifically saying this or that based on the allegations. Because I don't know if the children know. We can ask if Ms. Hill, do the children know what the exact allegations are?
No.
From your knowledge?
No.
Okay. And do you know whether you've informed Ms. Schmelzer of that? Do you know whether she knows whether or not you read the allegations to the children?
I mean, we haven't had that. I don't think we've had that conversation, but we wouldn't.
You may not have had that specific conversation with her before today, but didn't you testify to that today?
Yes.
Was
yes.
Ms. Schmelzer on the Zoom box when you said that?
Yes.
All right.
Your Honor, this is not about what I know or don't know. I mean,
Let's
my
move
job
on.
is to present
Next
information
question.
to the court.
Next
Thank
question.
you. Ms. Hill, one of the allegations specifically that Ms. Kloosterman made was with respect to Callie, that Mr. Kloosterman would kiss her from hip and down her leg. Was that the allegation that you were investigating?
That was part of it, yeah.
And in Callie's interview, was there any questioning or discussion about the appropriateness of Mr. Kloosterman kissing his daughter?
I guess in a roundabout way that was tried to be brought up as far as like bedtime routine or different things or boundaries and that stuff. And that was never disclosed specifically from the child.
There was nothing to indicate that any kissing would be outside of the normal parent-child appropriate relationship.
Yes.
Did you feel that in the interview, Callie was invited, if something like that was occurring, she was invited and had the open opportunity to discuss it?
Yes.
And again, she did not.
No.
Did Callie appear to be truthful in your observations in her interviewing?
Yes.
And do you have any reason to believe in your training and judgment that she was not telling the truth or was coached or afraid to tell the truth?
No.
Then now I'm turning to the interview with Kelsey. Did she make any disclosures?
No, she did not.
Again, did you invite her not you, I'm sorry, the interview, in your observations, the interviewer, did the interviewer invite her to have an open space to talk about anything related to those allegations? I know you didn't ask specific questions, but were those topics sort of initiated?
Yes.
Okay. And again, did Kelsey make any disclosures or statements that made you believe that these allegations had any merit?
No, there was no concerns noted.
Okay. And did Kelsey appear truthful in her interview?
Yes.
Did you have any reason to believe that she, Kelsey, again, was not telling the truth, was coached or afraid to tell the truth?
No.
And did Kelsey confirm that she felt safe with both parents?
Yes.
Not just safe, but that she had a relationship with both parents?
Yes.
And you also interviewed Kelvin, which is the 15-year-old son. Is that correct?
Yes.
And did he make any statements or disclosures about safety concerns in either parent's household?
No, he did not.
Did he appear truthful in his interview in your observations and training?
Yes.
Any reason to believe that Kelvin was not telling the truth, was coached, or afraid of either
No.
parent? Any disclosures about physical abuse or violence between the parents in front of the children by any of the children?
Without, I guess, rereading the interviews, I do recall there being something brought up, and I'm not sure by which child, but regarding like parents arguing, like, or fighting, that kind of stuff. But nothing that would necessarily make us substantiate, I guess, for improper supervision based on our policy definition.
And fair to say, adult parents sometimes argue, right? That's not uncommon.
Yes.
But my specific question was as to physical, getting physical during these arguments. None of the children disclosed that, did they?
In regards to their parents, or like to them, or to them, to the children, or to the parents to each other? I guess what
I don't think it matters. I read your report.
Okay.
I mean, do you need a minute to refresh your recollection on your report?
I was just making sure I understood your question correctly.
There was no discussion of any of the children of physical violence in the home.
No.
Is that correct?
Yes.
Immediately following the interviews with the children, did you speak with Ms. Klusterman while she was there at the Children's Advocacy Center?
Yes.
What did you share with Ms. Klusterman?
We had discussed that none of the children had made any disclosures at this time that were of concern, and we had discussed that there was not a need to extend the safety plan any further. And then I had called, I believe, Kevin after that and discussed that the parenting time could resume.
Who else did you interview or meet with during the course of your investigation?
I met with Kevin's mom, Kevin, when we met at your office. Trying to recall who else I talked with. I can't recall off the top of my head who else I talked with.
So Miss Kloosterman, Mr. Kloosterman, the 3 children, and Mr. Kloosterman's mother. You can't recall talking to anyone else.
Law enforcement. I know I talked with the Women's Resource Center at one point, in case conferences with like my supervisor.
And throughout the course of the investigation, the allegations made, and your interviews, if something had come up that you felt you needed to talk to someone else, a teacher, a therapist, a doctor, would you have done that?
Yes.
Okay. So, I mean, part of the investigation, you're following a trail. Is that fair to say? You're gathering information and then determining if you need to gather more information, right?
Correct.
And in this particular case, you didn't feel that there was a need to speak with anyone else, that nothing came up that said, oh, you need to talk to the doctor or you need to talk to a teacher, right?
Correct.
And throughout the course of your investigation, again, the only person, the sole person that had believed she had firsthand knowledge of anything, including interviewing with the children, was all Miss Kloosterman, right?
Correct.
Not a single other person that you worked with in the course of this investigation made any allegations or brought forth any facts that they saw themselves personally that caused you concern for these children.
Correct.
Did you ultimately close the investigation?
Yes, it was.
Do you recall when you did that, when you closed the investigation?
It would have been right around the end of August, I believe.
And what was your ultimate conclusion when you closed the investigation?
That it was unsubstantiated.
And what does unsubstantiated mean?
Like no preponderance being found for what the allegations were, which was improper supervision and sexual abuse.
And what does preponderance mean?
So to substantiate an investigation, you have to find I guess, preponderance, and what I believe for a criminal matter, it'd be like at least beyond a reasonable doubt. For a CPS matter, there has to be a preponderance, is what they call it. Just that there's evidence, some type of evidence that this is truthful.
So would it be fair to characterize it as you would have to find something that indicates more likely than not versus the criminal standard of beyond a reasonable doubt?
Yes.
So you would agree there's kind of like a lesser standard for CPS before they make a finding versus law enforcement. Is that kind of why you guys do joint investigations, but you can come to separate conclusions?
Correct.
And so in this particular case, you found that there was no indication of any evidence of any of the allegations.
Correct.
And if you dated, I apologize, if you dated your report September 6th of 2023 as to when you concluded your investigation officially, does that sound correct?
Yes.
So do you feel like you fully investigated this in over a month's time, almost 6 weeks?
Yes.
Do you feel confident in your conclusion?
Yes.
To your knowledge, did law enforcement also close the investigation with no charges or further action taken?
Yes, they did.
I guess let me strike that. Did you inform Ms. Kloosterman of the outcome of your investigation?
I did.
Do you recall about when you did so?
Typically right around when I submit my report, I will follow up with parents and let them know that I'm closing it out.
And did you share with Ms. Kloosterman, you found no indication that any of the allegations were true or believable, or there was just simply nothing? Did you inform her of that?
I don't believe I used those exact words, but yes, that we were closing out the investigation.
What words did you use?
Just that there was not like enough evidence, and at this time we're closing out the investigation.
Enough evidence versus no evidence.
Honestly, I don't know the specific words I used in my conversation with her.
Did you make it clear to her that it was CPS's position that this probably wasn't happening?
I mean, I don't recall our conversation being super long, more just a touch base that, hey, like we're closing out this report. At this time, we don't have enough to do anything with it.
And so there were no further safety plans or services offered to the family as a result of these allegations?
No.
And you believe that conversation was had with Ms. Kloosterman sometime around the beginning of September, correct?
Yes.
I have no further questions for this witness.
Thank you. Ms. Lentz, do you have any questions for this witness?
Just briefly, Your Honor. Hi, Ms. Hill. When this report initially came in, was there a reference to text messages?
You mean from like parents, like just texters? Yes, there was some reference to that.
So in a reference to text messages, do you know, was the reference in regard to conversations between Mr. and Mrs. Kloosterman?
Yes.
So in this whole, Ms. Kloosterman's the only one that's made these allegations, and their verbal allegations. There was actually documents in the form of text messages to support her claims, correct?
I believe there was like a screenshot she had shared. Yes.
And did Ms. Kloosterman actually text you a picture of that screenshot text message that was referenced by the initial reporter?
Yes, she did.
Okay, so be fair to say Ms. Kloosterman isn't just pulling this out of thin air. She had some form of documents to support her claims.
Yes.
And Ms. Hill, when you do an initial report or follow up on a call, do you research if there's been any previous CPS involvement with that specific family?
Yes, we do.
And was there previous CPS involvement with the Kloosterman family?
There was, and I'm trying to recall off the top of my head. I believe it was a couple years ago. But there was.
And to your knowledge, were those previous involvements or previous involvement substantiated or in terms of CPS lingo?
Would I have time to pull it up real quick to refresh my memory, or?
No, if you can't remember, that's all right.
Okay.
Ms. L, is it common for CPS workers to develop a safety plan?
Yes, it is.
And you testified that this particular safety plan, it was created by you and your supervisor, is that correct?
Yes.
So to be clear, it was not Ms. Kloosterman who put that language in the safety plan.
Correct.
Ms. Hill, do you think it puts parents, for lack of a better phrase, between a rock and a hard place when they have a safety plan and a parenting time order in place to decide what one to follow?
Yes.
And you testified earlier that it's CPS hope that they follow the safety plan. Is that correct?
Yes.
Ms. Hill, is it possible for someone to have a belief even though CPS says otherwise?
Objection, speculation. How would she know what somebody, specifically Ms. Kloosterman, believes?
I didn't specify Ms. Kloosterman, Your Honor. I'm asking
anyone. And it's even more speculation.
I think you can follow up with some foundation questions. I don't know how speculative
Sure.
it is, but you could follow up and then easily fill that in.
Ms. Hill, in general, Do you ever have parents that continue to believe abuse, neglect, whatever is happening, even though CPS has unsubstantiated their claims?
Yes.
And Ms. Hill, I'm sure you do great work, so don't take this personally. Is it possible for CPS ever to be incorrect with their conclusion?
Yes, I would say it's a possibility.
I have no further questions, Your Honor.
Any redirect, Ms. Schmelzer?
Thank you. Ms. Hill, there was a question about a text message, one single text message between Mr. and Mrs. Klusterman, correct?
Yes.
And that was over 5 years old at the point that you were investigating. Is that fair to say?
Yes, I believe it was from 2018.
And that was solely provided and generated by Miss Klusterman, no one else, right?
Correct.
And Mr. Klusterman was asked about that text message, wasn't he?
Yes.
That text message was not documentation supporting Miss Klusterman's claims, was it?
There was something in the text message related to the swimming. I can't remember specifically what it said. It was, I guess, strange the way it was worded in there. I can't specifically say. They're just, because it was from 5 years ago and that was all we had, there wasn't enough. I discussed with law enforcement. I'm not saying that it was nothing.
Mr. Klusterman didn't recall sending that text and or informed you that it was taken out of context. Isn't that correct when you investigated it?
Yeah, the concern was brought up regarding maybe there was like a typo or that it just, I don't know. There was a lot of different things, I guess, that we kind of talked about regarding that text message.
On its face, that text message in and of itself did not show that there was abuse happening, did it? If you just read it totally in isolation.
Yes, that would be accurate.
Okay. And have you ever seen people, even in your own life, in your investigations, they make typos in texts, right?
Yes.
Happens all the time.
Yeah, I mean, it can happen, sure.
And you mentioned that that text message was from 5 years ago. Did that influence whether you believed that that single solitary one and only thing was enough to do anything with this matter?
No.
Do you take concern with a parent who brings about something that occurred 5 years ago, 5 years after the fact? Is that way into your investigation at all?
Concern with the parent as in regards to, what do you mean?
Well, let me state this differently. If a parent's truly concerned about abuse or neglect occurring, do you consider the fact that they waited 5 years to tell somebody, waited until a divorce is pending, waited until a custody battle is ongoing before they brought it up? Is that something you take into context?
I mean, I don't know exactly how to answer that. Again, I mean, we just talked about the text message not being anything in and of itself. So I don't know that at that time, maybe that parent even could recall that being something. So I guess I don't know how to exactly answer that.
Let me ask this. Did the fact that the text message was 5 years old have any influence on how much weight or consideration you gave it in your investigation?
Yes.
And what weight or consideration did you give it, considering it was 5 years old?
Just that it just wasn't recent in time in regards to the allegations. And that was just like a one small piece that we had of it.
And And she provided nothing else in between 2018 and present.
Not that I like, if you mean a documentation, something like that, or
Correct.
not that I recall.
And your testimony was that this text message was provided to you as a screenshot from Miss Kloosterman to you, right?
Yes.
And you have no indication whether it could have or was altered in any way or not.
I wouldn't have a way of knowing that, I guess.
With respect to the safety plan, how do you explain that you told me on Friday, July 28th, that the safety plan was directed by the parent, and your testimony today was that it was directed by you and your supervisor?
I guess I don't recall you saying it was directed by the, or I guess I don't recall that. The conversation that me and you had?
You recall that there were a lot of phone calls between you, me, and your supervisor on Friday, July 28th, discussing the fact that CPS doesn't have the authority to tell a parent to deny parenting time ordered under a court order, correct?
Yes, that is correct. We did a voluntary safety plan with the parent.
And you told me on July 28th that that safety plan was directed by the parent, not you and your supervisor. Is that correct?
Yes. I don't recall saying that specifically to you. I don't know in what investigation I've ever had a safety plan being directed by a parent. That's always coming from us working with a parent.
Okay, so was that something you were just saying to me because I was pointing out that CPS didn't have the authority to do that? And so you said that to me?
Again, I don't recall saying those words to you. I guess I'm sorry if it was misconstrued, but in any investigation I've ever done, we work with parents, we do safety plans, but I've never had a parent direct a safety plan.
Is it your position today that CPS has the authority to tell a parent to violate a court order by retaining children?
I mean, I think it's made clear that CPS doesn't have the authority. I mean, what I can say again is we safety plan, we hope parents work with us. The safety plans are voluntary. Lots of times I'll follow up with friend of the court to let them know. I don't know what else I can say, I guess, in regards to that.
Do you believe that in this instance, you were clear with Ms. Kloosterman that the safety plan was voluntary and that you did not have the authority to tell her to violate this court's order?
Yes, we had that conversation.
I have no further questions.
Any final questions, Ms. Lentz?
Just briefly, Your Honor. Ms. Hill, do you have any knowledge as to if Ms. Kloosterman returned the children immediately following the interview on Tuesday?
Yes, I believe they went right to Kevin's that day.
1 second, Your Honor, thank you. And Ms. Hill, the text message that was referenced, it was kind of teed up to be a typo. When you interpreted that text message, did you think it was a typo?
I think we talked about a lot of different possibilities. And I know we had this conversation with law enforcement too. Did I think that was strange in a text? Yes. But we also had, again, kind of all these other things that it could have been. And one of them that was shared was like, you know, is it a possibility that this was a typo?
And Ms. Hill, to be clear, it was phrased that like Miss Kloosterman is the one bringing up these allegations. She was not the reporter of this investigation.
Objection, this goes beyond the scope. I mean, she could have asked it in her original cross. This is recross. I didn't bring up any of this in redirect.
Well, to be fair, I believe that Ms. Lentz, you objected to this exact issue as to who identified, and so I'm gonna continue my ruling.
Okay. And in my question, I'm not asking for the identity to be disclosed. I'm just asking if it's Miss Kloosterman.
I'll allow that.
Okay.
My objection again is it goes beyond the scope.
I understand. Overruled.
I think, okay. Was Miss Kloosterman the initial reporter?
No, she was not.
So this testimony about Miss Kloosterman brought this up 5 years later and Miss Kloosterman, all that, that's not accurate because Miss Kloosterman was not the reporter, correct?
She was not the reporter. Correct.
No further questions, Your Honor.
All right. Thank you very much, ma'am.
Thank you.
Your Honor, do I get redirect since this was my witness?
Yep, you got redirect. These are the final questions.
Well, she got to cross last.
All right, next witness.
And I called the witness. And
Your next witness, please.
Your Honor, for the record, I would like to do another redirect and ask because Ms. Lentz went beyond the scope of her original cross and the original redirect, and I have a follow-up question based on what she just said, and this was my witness originally.
I know I disagreed with whether or not you had that opportunity. You did. Next witness.
Your Honor, I argue that I did not.
You've made your record. You're welcome to file that in an objection following this hearing. Your next witness, please.
For the record, I would like to call Miss Mindy Hill and ask a follow-up question. Your Honor, I'm asking to call Miss Mindy Hill. I have not released her.
I understand that. Next witness.
Miss Mindy Hill.
Okay. If you have no further witnesses, then I guess we're all set.
I have further witnesses, but I'm recalling Miss Mindy Hill, and I did not release her as a witness. She's under subpoena, and
the court released her.
Your Honor, I didn't release her from subpoena, so I'm recalling Miss Mindy Hill.
The court released that witness. I followed the same exact format with every single witness, and you know that.
Your Honor, I don't believe so. I believe Ms. Lentz was always given the opportunity to ask.
She has final questions with the other attorney, and we're all set. I don't believe that she went beyond the scope. You're saying that. We just disagree. That's okay. I disagree with whether or not you had an opportunity to fully examine that witness. We're all set. I released the witness. I'm not going to argue with you anymore. We're either going to go on to the next witness or I'll end this hearing right now.
I'll call Kevin Kloosterman, but for the record, I would
Your
still like to call
objection is
Miss Mindy
noted.
Hill.
That's perfectly fine. Everything is fine. You can file an objection to that. That's the way it works.
Your Honor, I disagree. I have clear notes that indicates that when
All right,
plaintiff
Mr. Kloosterman, would you raise your right hand, please?